everybody doing?
Hello.
Hello.
Hello. Well, I'm really excited to be here. It's nice to actually be talking about something happy after 4 years of not so much happiness. Do you guys want to introduce yourselves real quick before we jump into the topic area? Kate, do you mind going first?
Sure. My name is Kate Lincoln-Goldfinch, and I am a private immigration lawyer based in Austin, Texas. I also am board chair of VECINA, which is something I'm very proud of. I love this organization.
Yay.
Talk all about it if you want me to.
Awesome. Tamara?
My name is Tamara Jezic. I am a private immigration attorney. Our firm is based in Maryland. It's called Jezic and Moyse, and we have offices in Virginia, and I do most of the work in Virginia.
Awesome. Jen?
Hi, I'm Jennifer Ibañez Whitlock, and I am policy counsel at AILA. So I'm based in outside of our DC office. And previously, I was in private practice for many years with the lovely Lindsay Gray. We had our own law firm in St. Louis, Missouri.
Awesome. And I'm Lindsay Gray. I run VECINA, and I'm really excited to have this particular panel with these particular ladies. So today's format's super casual. Please feel free to post comments and questions in the chat box or underneath the video, and we can address them as we get to them. So please feel free. First, I just want to talk about, for anyone that's sort of unfamiliar with asylum law generally, what are the elements of asylum? What does somebody have to prove to be granted asylum in the United States?
I'll take this one. So essentially for asylum, you have to show that you have you meet the definition of a refugee, which is that you have a well-founded fear of persecution based on one of 5 protected grounds, which are race, religion, nationality, political opinion, or membership in a particular social group. And that last element is the one that has been, I would say, oh, Joanna says she can't hear anything. I don't know. Can you guys hear me talking?
I can hear you talking. Can anybody else, can somebody else comment in the chat box? Because I know we've got a number of people listening if they can't hear anything. We definitely want to make sure everybody can hear.
So defining, great.
Okay.
Thanks, Kenzie. It's much more obvious, right, when a claim is based on race or religion or political opinion. That's not to say that there hasn't been case law developed along those lines, but with particular social group, it has sort of been, the catch-all way that asylum seekers have applied for asylum, and a lot of Central American asylum seekers have fallen under persecution based upon their membership in a particular social group. And so the cases that we're going to discuss today fall into that category of whether someone is part of a particular social group for purposes of asylum eligibility.
And for particular social group, like, is that defined in a statute somewhere, or, anything like that? Or how do we know what a particular social group is?
It's developed through case law, and it has narrowed and narrowed and narrowed and narrowed, and it got teeny tiny during the Trump administration, where it was next to impossible to qualify for asylum under a particular social group. Now we're seeing it grow a little bit, but it still has been whittled away over the years, and it's still a very difficult element of asylum, and showing the nexus that someone was persecuted on account of their membership in their particular social group. And these are very difficult things to prove in an asylum case.
So the 2 cases that came out last week are called /abrogating matter of AB and matter of LEA, and they both talk about particular social groups. What types of particular social groups does matter of AB address, and what type of particular social groups do matter of LEA address?
Is this one for me?
I don't know. Whoever wants to go. Yeah.
So I can take this one, and then Tamara, you can take over if you'd like. So AB is about basically domestic violence claims, whether victims of domestic violence can be members of a particular social group. But of course, we'll talk about like circularity and how you wouldn't define a particular social group by someone who has been a domestic violence victim. But that's the body of cases that we're talking about under AB. And then in LEA, we're talking about whether nuclear families can constitute a particular social group, which is, both of these things are very common in Central American asylum claims, domestic violence, and cases where a nuclear family has been targeted, perhaps by a gang. And so these two cases in particular, affected a massive amount of Central American asylum cases.
Definitely. And I even think AB and, covered even broader than that, at least in terms of its dicta. I mean, AB talked about like gang-based violence and things of that nature, which cover thousands of claims where people are fleeing persecution on account that they, refuse to join a gang or, are being recruited or things of that nature. Tamara or Jen, do you want to add anything about sort of like the subject matter and scope of these two cases?
Go ahead. I did want to add that I think LEA is mostly about nuclear families, but when we're talking about family as a particular social group, we're certainly not limited to nuclear families as long as we show that they're particular, immutable, and socially distinct. In the Fourth Circuit, where there's very developed jurisprudence on family as a particular social group, the sort of the quintessential case is Crespin v. Holder, and there the family at issue was a nephew and his uncle. So I would say I usually frame my PSGs in family-based case as family, not necessarily nuclear family.
Sure.
And then what was interesting about the AB dicta about gang cases is that presumably there was no gang involvement in Ms. AB's case. It was a domestic violence case. And the Attorney General just wanted to throw in there that he didn't think gang-based cases were viable.
Yeah, there was a lot of that. And even LEA, I think said, well, this generally won't work. There was a lot of that, right? Like, well, these cases generally won't pass muster, but of course we're still going to look at them on a case-by-case basis. And I think as much as, and we were talking about this the other day, Tamara, you were bringing up this point, as much as these cases have been abrogated now, it's still so important to create a record, right? As you were talking about, that those things are socially distinct and defined with particularity. So, if someone is a second cousin or they're not part of a nuclear family, like that society recognizes that person as part of this family group and that the family group in itself is socially distinct. And so I think, right, we're still living in that world.
Yeah, and especially in our, as we know from working with our clients from Central America, cousins who are second cousins, they'll call themselves cousins, but they might even refer to themselves as brothers, or so sort of our concept of what a family is in the United States doesn't necessarily match with our clients' experience. Our clients' experience of their family is much broader than ours. But I think as long as we define the family, it might be helpful to draw a family tree for the immigration judge, for example. The judge should find that someone's family is a particular social group.
For sure. And Tamara, I have sort of an in the weeds question for you. You mentioned you were talking about Fourth Circuit law and just a moment ago. For people who practice in circuits where the circuit court has adopted either AB, LEA, or something similar, how do people move forward? How do practitioners move forward, from here on out, even though the cases have been abrogated at the BIA level?
Well, I was just listening to a podcast yesterday. It's called Immigration Review. It's a fantastic podcast by Kevin A. Gregg is the host. And what he pointed out was that most, if not all, circuit court cases where they're sort of deferring to AB, the reason that they're saying AB is okay is because of Chevron deference. They're deferring to the agency's interpretation of an ambiguous term, which is particular social group. And if AB is no longer there, there's nothing to defer to.
Right.
But we still should be looking at what the circuit courts are saying about these types of cases. So, for example, the Fourth Circuit rejected a case that was something like married women who are victims of abuse. And the court said, AB said that we can't have a group that's circular. And the Fourth Circuit said this is a principle that was applying even before matter of AB. So you still want to look at AB and be able to craft your particular social group in a way that would satisfy even the adjudicators who are looking at cases with an AB eye.
For sure. So sort of talk, because you both you and Kate have brought up circularity. So I want to get there because I think it's important. So talking about sort of like, where are we now with defining particular social groups? Can we talk a little bit about the three sort of elements that we have to prove for a particular social group? And then also like, what is circularity and what do we do to avoid it? Sorry, that's a very loaded question.
So the three points are immutable, particular, and socially distinct. And so a mutable characteristic is something that can't be changed. And the seminal case on that is matter of Acosta, which is the group of taxi drivers. And the idea is that this characteristic is something about somebody that they cannot be expected to change or that they cannot change. I don't know about you, Tamara, and all of you, but I think of particularity and social distinction as a very fine like needle to thread, where particularity is, small enough that the group doesn't encompass too many people, too many individuals in the group, but socially distinct enough or visible enough, although I know we don't use visibility, but that society also recognizes this group. And it's a very difficult thing to prove. And also with the circularity that the membership is not defined by the harm. So I don't know what you have to add on that, Tamara.
Yeah, definitely. The circularity means that membership cannot be solely defined by the harm. Mm-hmm. And one way you can avoid the circularity the problem in cases such as matter of ARCG, where the BIA found married women who are unable to leave their relationship as a particular social group, you want to put in your record why your client is unable to leave the relationship. It's not because of the abuse, it's because of other factors. I mean, one reason your client is not able to leave the relationship is because of the abuse, but you don't want to limit your record to that reason. So there might be, in Guatemala in ARCG, there's a lot of pressure that, married women are not allowed to become unmarried for societal or religious reasons. I think I have a little bit of a disagreement with you on particularity. I think particularity doesn't encompass size in any way. I think that a particular social group can be huge as long as there are clear boundaries on it. And the Fourth Circuit did issue a great case recently called Amaya, and it said that particularity is actually a matter of law and social distinction is a matter of fact. So they're very, very different. And there are a number of cases like CC versus Holder, I think that's in the Seventh Circuit, that talks about how particularity doesn't mean it can't be big. So the women in El Salvador, it can be a particular social group, for example.
Yeah, that's what I was going to ask you, Tamara, is based on these recent cases, what are some of the examples of groups that are particular that are still large? I'm in the Fifth Circuit, so basically,
okay. It's hard.
Nothing works here. I'd love to hear. I think it would be great for people to hear what works, in terms of large and yet particular groups.
Yeah, I mean, you can take the example of groups recognized by the BIA, such as gay Cubans. That's a very big group. And
haven't there been, wasn't there a BIA case law of like women from a certain tribe who may be subjected to female genital mutilation?
Yeah, matter of Kasinga. Matter of H is about a sub-clan in Somalia. That can be a big group. And then there are a number of circuit court cases that affirm that women in a country on its own can be particulars, such as Perdomo in the Ninth Circuit. There's De Peniagua Pena versus Barr that is recent, I think, from 2020. That says that women in a particular country can be a particular social group. I think you've got an uphill battle in the Fifth Circuit I do recognize that, and I feel for you.
Yeah, I mean, one of the things we do is, and I'm curious to know whether you do this too, Tamara, is propose a handful of PSGs in a case, and some of the ones that you're proposing are women in El Salvador, and some of them are much more whittled down, and see maybe one of them will stick.
Yeah, I mean, we do a number of motions to reopen cases out of Texas. So that's my experience with Fifth Circuit law on asylum, and it's really hard. It definitely is. So you just need to pull in circuit law from other cases. But there's some good ones in the Fifth Circuit, and I don't have them in front of me, but Lindsay actually hosted a CLE for Texas practitioners, and I did pull out a handful of Texas cases or Fifth Circuit cases that were pretty good. But yeah, it's definitely a challenging circuit. For
sure. I think continuing to make creative arguments and proposing creative particular social groups is of utmost importance in the Fifth Circuit and everywhere. Joanna says the PSG, she knows there's a case that can't be defined. The PSGs can't be defined solely by the harm. And I think we got to that. But then she also says it might be a Supreme Court case. It was an example of former employees of country X's Attorney General's office who have received death threats could be a good PSG. It's my understanding that that's true based on what we just talked about. Is that everybody's understanding? I'm not familiar with the case, but, or at least the case that she's referring to. Anybody have any idea?
I can probably find it. I'm looking at my computer right now, but we can move on.
Yeah. And then, so this is social distinction factor still required? That's what somebody else is, that's what Naima is asking. Is social still a requirement?
So it is, and I'm interested in what Tamara said about this case, which I haven't read, that holds that social distinction is, what did you say, that this is a matter of fact, but particularity as a matter of law?
That's Amaya in the Fourth Circuit.
I'm going to read that one.
I'm going to post in the comment the cases that I found. Or can I do that?
I don't know. If you private, I know that if you private, if you chat me, I can post it.
Okay.
So.
Okay, one is MEVG. The social group must exist independently of the fact of the persecution is one. A social group cannot be defined exclusively by the fact that it is targeted for persecution. That's in matter of CA.
Okay, awesome. Oh. All right. Sorry, guys. Technical. And then, so Joanna has a question. Can you also discuss, contrary to many IJ's beliefs and contrary to what is stated in AB, she thinks PSGs do not have to be homogeneous, i.e. a PSG does not fail cognizability just because it is heterogeneous? That is a loaded question. Tamara, you want to see if you can take that? Or?
I mean, I think I've seen a lot of IJ decisions that say, oh, this PSG can include people of all ages, all nationalities, all genders. And you can do that. You can sort of take a group that's already been recognized by the BIA, such as gay Cubans, and say you can say the same thing. It can encompass people of all ages, of different backgrounds, different religions. So I think that's just one of the best cases to cite. And is it Tabasco, matter of Tabasco Alonso? Is that what it's called?
I am not sure. You're talking about the BIA case about defining, agreeing that gay Cubans is a PSG.
Yeah.
I don't know. I can look though.
Okay. Toboso, Toboso Alfonso, matter of Toboso Alfonso. That's from 2012. I think it's from, oh, I'm sorry, it's from 1999. 1990?
Oh my goodness. Okay. And it's Toboso, Toboso Alfonso? Okay.
Yeah.
Got it. All right.
And then Amaya also talks about that, Joanna, in the Fourth Circuit. There's a good quote in Amaya about the fact that a group is internally diverse doesn't mean that it's not particular.
Got it. I want to turn now to gang-based cases. What sort of tips do you all have for practitioners, now that these cases have been abrogated, and sort of what changes for practitioners across the board that are litigating these types of cases? Anyone? I think, yeah, go ahead. Oh, I was just going to say, one of the things that Tamara mentioned when we were on our sort of prep call was that, still, checking the political opinion box for gang-based cases, because, refusing to join a gang or being anti-gang in any way, articulating that you're not supportive, is in fact a political opinion. I think that should continue. And there's a whole host of BIA cases that are not super favorable, even before AB, are not super favorable to gang-based related asylum claims. And so I think for practitioners, they would want to continue doing that. Sorry, I'm looking at the comments. Does anybody else have any thoughts on, the way the game changes in terms of, not the game, the way that we change litigation on gang-based asylum cases?
I think if anything, LEA and AB taught us to exhaustively prepare and choose a number of different protected grounds. And I think we want to keep doing that. I think I have prepared the unwilling, unable prong more than ever in the past 2 to 3 years. Whereas, to me, it seems obvious that a country like El Salvador is, unable or unwilling to protect somebody from gang-based violence, but it's not obvious to an immigration judge. So you want to include evidence, not only country condition evidence, but also evidence from your client's personal experience. Like, my neighbor was abused by her husband, and she called the police a number of times, and they just told them to go to couples counseling, things like that. Because usually your client will either have her own personal experience or have a friend having her own personal experience that is mirrored by the country reports. So definitely look for the political opinion claim and the religion claim. A case that you all should know from the BIA is matter of SA. It's from the BIA in 2000, where a young woman from Morocco was abused by her father, and the BIA found that the abuse was on account of her religion, because her father was a very orthodox, strict religious man, and the daughter, the client, the respondent, had liberal Muslim views. So she did things like she wore miniskirts, and she talked to men who weren't her relatives on the street, and her father punished her for that. So those are good things to ask your client. Many of our clients from Central America are very religious, usually Christian, and several of my clients, their husbands or their boyfriends have used the Bible or used the church to justify their abuse. Or the client, when she asserts herself, she says, she actually says, one reason that I asserted myself was because I believe that God created all men and women equal. And so when I told my husband that he wasn't being a good Christian because he was beating me, he beat me even worse. So religion is a good thing to bring up. And then political opinion is great. Ask your client how she feels about, and this is in the domestic violence context. And again, usually the victims are women. And I'm not saying that they always are. Ask your client how she feels about equality between men and women, and what happened when she asserted her right to be treated with dignity. What happened when she asserted her right to work and her right to move freely without being controlled. Usually you'll hear that the abuse escalated when your client asserted her rights, and those are political opinion claims. And also, I would always suggest getting an expert for your gang-based cases that aren't necessarily gender-based. Gender-based are good ones, but if you have one like a recruitment case and you can't find a family hook, or you can't find a clear hook, get an expert to testify that gangs act as political authorities in the country, and someone refusing to comply with the gang's demands is asserting a political opinion, and they're going to be punished on account of their political opinion. And also that gangs will impute a political opinion to people who resist them and will punish them for that imputed political opinion. And the country condition evidence is great, particularly in El Salvador, about how gangs act as de facto political authorities.
Yeah, that's really good practical advice. Someone is asking if we know of any organizations that are working on practice advisories for motions to remand for cases previously decided based on AB and LEA. Jen, I think I saw something maybe coming out of AILA's partner org, AIC, but I don't know if it was based on motions to remand.
I don't think it's based on motions to remand. If it was going to come out, it would probably come out through the American Immigration Council. There's always the possibility that AILA's national committee, the Asylum and Refugee Committee, might consider it, but it's certainly something that I'll keep an eye out for, and I'd be happy to share it with you, Lindsay, to circulate to folks if I see that someone's doing the work. As you can imagine, there's just a host of different things out there that the council I know is litigating on, and this being one of the more important ones, certainly, but a couple different things, irons in the fire, so to speak.
For sure. Kate or Tamara, do you guys happen to know? I would assume that it would be AIC. Yeah, okay. And then there's a question, can we discuss, and I think this was like mentioned very briefly and then passed up, but discuss how the vacatur of AB affects the government's willingness and ability to protect. Anybody want to talk about that, sort of like how that landscape changes, or arguments we can make to immigration judges?
Well, I think Merrick Garland actually states in the opinion that confusion that was caused by these cases on the unwilling and unable prong, because I think it's an AB.
Yeah.
I just printed it out. Let me take a look.
I remember that they tried, and I'm like blanking on the exact language, but they tried to heighten the standard.
Yeah, they said complete helplessness or condoning the activity.
Mm-hmm.
Yeah.
Right. But the law, that's not in, I think, a footnote of AB, is that the government has to be unable or unwilling to control.
Right.
Which is not, demonstrates complete helplessness.
Right.
So, yeah.
And the Attorney General, yeah, it is in an AB. He says, other portions of AB 1 have spawned confusion among courts. For example, the courts of appeals have disagreed about whether AB 1 changed the unable or unwilling standard the board has long applied to determine whether private violence qualifies as persecution. So, our current AG is saying that our prior AGs confused the matter. So I think that's very helpful.
Yeah, definitely. And just to be, just to sort of go there on a grander scope, there was this whole attack against claims that were related to private persecution, right? And so it was basically said, what the former administration, I think, tried to do was basically say any persecution that wasn't at the hands of the government, right, which is essentially a cat claim, that all of those are not real, or they're not going to pass muster. And so I think this is sort of a step back in the right direction, where the law has been for decades, that it's the government has to be unable and unwilling to control, not that they have to actually conduct the persecution or be totally helpless. And I think, an example of that is, like, my thought goes to potentially like LGBTQ protections, where laws are on the books, but nobody's enforcing them. An example of, well, the government took a step, but not in practice, nothing actually happens.
To that end, Lindsay, I think what the cases did, and Garland points out in matter of AB, that the cases could be read to create a strong presumption against asylum claims based on private conduct. Because even in AB and LEA, the attorney generals were like, I'm not saying all claims,
right?
But it really did create a strong presumption against gang-based claims or claims based on violence by non-state actors. And Garland is saying here, none of that. There's no more presumption against these claims. And I think that's very helpful. And I think it's very helpful.
Yeah, I think that's a fair point, that a lot of the statements, I mean, I think even like in LEA where they basically, tried to throw out the family-based claims, even then they said, well, we'll consider it on a case-by-case basis.
Right.
But
while
now,
at the same time saying most families aren't socially distinct.
Right, exactly. And so now we're no longer pushing the snowball, at least in theory, we're no longer pushing the snowball up the hill, right?
I mean, these cases are just basically the best example of the politicization of the immigration courts under the Department of Justice. I mean, right? Like, we're all kind of dancing around the issue. Like, they want to deny Central American claims. And this just kind of gave them the ammunition to do it.
Right.
I know that a lot of the people here are experienced asylum practitioners already, but a lot of the VECINA watchers are pro bono attorneys who are doing these cases and don't have a lot of experience with asylum. And just one thing to point out that I know is obvious for a lot of people, but is, in many of these Central American cases where the gangs or the persecutors, they have infiltrated the local governments or the police agencies. And so demonstrating that in your evidence or in an expert report is also very useful along these lines. If you can't, those are the ways that you can show government unwillingness or inaction. And it's pretty easy to find that type of evidence in most of these cases. And most of your clients are going to tell you that. I couldn't go to the police because that would have created further harm for me.
Definitely. And like, if you have, I know I've seen a number of examples where the abusive spouse has a family member that's a police officer.
Oh, yeah.
Making sure that you document, like, it seems weird to, put in your client's husband's brother's birth certificate showing that they're brothers. But if you can get a hold of it and can show that familiar relationship, and of course, articles that show the corruptness of the government in that regard, and society's view of women as property. That was an argument that was made a lot over the past few years, that the society in certain countries and areas of the world viewed women as property, and so therefore they didn't have these rights. And in LEA, again, the out from LEA was that it's considered on a case-by-case basis, and so setting a really good record of all of the what's called country conditions evidence about the social distinction of family members, that and how they're perceived is really important, because again, it's not necessarily the same as it is here in the United States in terms of how we define family. Okay, let's see, just to address something that's going on in the comments. So going back to sort of looping back to the religion claim. So would you make an argument that religious views are political opinion, i.e. I am religiously opposed to gangs because they do things that are against my religion, violence, and etc.?
I think they overlap, definitely.
Yeah, I think also you could look to the church's anti-gang activities and use that as an imputed political opinion claim, that because the church has policies that are anti-gang or activities that are anti-gang, and even if you haven't participated in them, you belong to that church, and therefore the persecutors see you as anti-gang politically, then I think that's the way you could pull that in if you don't have like actual, express political opinion by your client.
Definitely. And another thing, sort of going back to something Kate just mentioned, is express. One thing just generally in asylum cases, I think that practitioners should do is make sure that we ask lots of good questions about what was said to them. So, so-and-so came to my house with guns. Well, did they say anything to you? What did they say? Because sometimes you will get, from an abuser, I own you, demonstrating his view of the spouse's property, or, you did this against the gangs, or you spoke out against us, whatever, statement that can show an actual reason for the persecution. And then you're starting to prove the nexus aspect, which is, that the persecution and the protected ground are linked. Definitely. Okay, let's see. Let me go back to our list of questions. So how does this affect, so someone has a pending asylum case that is based on one of these cases, LEA or AB, at the immigration court level, how does this affect those asylum seekers?
It helps.
That's right. I mean, you can add in so many more PSGs into your case. And if you haven't already filed your application or your supporting evidence, it's a lot easier. If you've already submitted your 589 and even your brief, I think you would need to supplement in light of these new decisions. But it just allows you to put in, I think, so much more is the bottom line.
Definitely. What about for those who have cases at the Board of Immigration Appeals that are pending?
So I would just jump in to say that I don't know if folks saw the memo from Vanita Gupta on the BIA case. That's something that we might want to share out to people watching just to have in their back pocket, because that speaks to the issue of pending before the BIA.
You're talking about so I got an email from her this morning about the priorities memo. Is that the one that you're talking about, or are you talking about something different?
Something different. It's a memo entitled The Impact of Attorney General Decisions in Matter of LEA and Matter of AB. It was issued on the 16th, and it's where she's basically directing the civil division of the Office of Immigration Litigation. They're the ones responsible for defending the decisions of the BIA when they're challenged in the Court of Appeal, the federal courts of appeals, that they should be taking some proactive steps to review any pending cases that may be actually affected. And then in the memo, it says something like, take appropriate steps in light of that development, including, importantly, actually seeking remands in appropriate cases.
Oh, awesome. Okay, great. Yes. Is that what you posted here, Jen? In the chat?
Yes, that's the one. If you can share that out, that'd be great.
I will share that. And Kate, is that the same one? I see you.
Yeah. Okay. I didn't see that she had already put it.
No, perfect. Thanks, guys, for helping me out. Awesome. All right, that's been shared in the chat. So if cases are pending at the BIA, folks want to be filing a motion to remand. We do not know of any orgs prepping a practice advisory on such things, but hopefully someone will. And then in terms of cases where they've been denied at the BIA level, Tamara, how should practitioners and asylum seekers move forward in those cases?
Okay, if you have a final order of removal from the BIA and you're within the 30 days, find somebody who's licensed and able to practice in the Court of Appeals and definitely file a petition for review. I don't think that you should rely on doing like a motion to reconsider without filing a petition for review, and you have a 30-day deadline from the date of the BIA decision. And once it's at the Court of Appeals, you can probably negotiate with an oil attorney or write an opening brief and hopefully get a remand. So if you have a final order of the BIA that has not been appealed, I think that's a hard question. I think each case is going to be different. A motion to reconsider needs to be filed within 30 days, but if you're within your 30 days, you should be doing a petition for review and maybe a motion to reconsider as well. I mean, that's a strategy decision, whether you do a petition for review in a circuit court of appeals along with a motion to reconsider or just the petition for review. Motion to reopen needs to be filed within 90 days. If it's a certain kind of motion to reopen, for example, for new evidence. A sua sponte motion to reopen can be filed at any time, and that might be something that you want to consider. And the case you want to look at is matter of GD that talks about a change in the law, which is an exceptional circumstance that would be a reason for the BIA to reopen a case sua sponte. So that's a good case to look at, and then decide whether you want to go ahead and do a motion to reopen sua sponte. I think every case is going to be really different depending on the strength of the case and the terribleness of the opinion and the client's personal circumstances. So I'm hesitant to give blanket advice about what to do if you have a final order.
For sure. Did you say the case was matter of GD?
Yeah, G, as in go. It's a
Yeah.
1999 decision. I don't have a site here. That talks about what you need to show if there's a change in the law for sua sponte reopening.
Got it. Okay. I've posted that in the chat.
Mm-hmm.
I think that's really helpful because I think people now, or at least I feel a little bit of overwhelm of like, this is so great. Now what do I do? What do I do for each case?
Yeah, if your case is pending at the BIA and there's not a briefing schedule yet, I think that the BIA is probably not going to take a look at it without a transcript. So you have some time. If your case is pending before the immigration court, you can always reach out to DHS to see if they would stipulate to relief. I mean, I think prior to Trump taking office, I think right before he took office, I had somebody, a DHS attorney, stipulate to relief under a matter of ARCG. So remember, that's possible.
What is I'm like, stipulate, I'm laughing because I'm just like, oh my gosh, I don't even stipulate to relief.
Yeah. So if you have a case, a pretty strong domestic violence case, send a letter to your DHS attorney assigned to the case to see if they would stipulate to a grant of asylum.
And I'll just jump in here that there's the interplay of the recently released Office of Principal Legal Counselor Advisors, OPLA memo, where it talks about certain priorities where it would be warranted not to just dismiss an NTA, but also in particular stipulates to something. AILA is actually collecting case examples from our AILA member attorneys. And I definitely have seen at least one case in which the trial attorney there agreed to not appeal an immigration judge's decision to grant asylum to someone based on the fact that they weren't an enforcement priority.
That's great.
Yeah, I was wondering about the enforcement priorities memorandum. I mean, and the interplay of those two things. I mean, hopefully, stipulating to relief or getting relief is the number one goal. But in other cases where that's more difficult, I mean, I know that every case will be different, but sort of any tips as folks are considering sort of the interplay of those two things?
We're still in the process of reviewing our cases to decide the strategy based on the new memo. So I don't have anything to report about the behavior of the ICE attorneys yet, or their. What about you, Tamara?
No, I don't have anything personally. I think the AILA DC group has been posting their experiences on Facebook. Some people have been offered dismissal of their case. Some people have been offered admin closure. Some people have filed joint motions to continue so that the DHS can better evaluate the case before actually litigating the merits hearing. So I think little by little, we'll be seeing how DHS is responding to requests for PD or admin closure.
On our end, the government relations team, in addition to asking for case examples, we have a national committee that's made up of the Immigration Customs Enforcement and the court AILA members who volunteer their time. And I know that they are working with the local chapters to try to get a sense of the engagements that they're having with ICE and OPLA on how they want these requests filed, what kind of responses we're getting. As you can all imagine, it's unfortunately probably going to be a bit arbitrary and based on your jurisdiction, how receptive those offices will be.
A question I think we should address, because I bet it's a question that's held by many practitioners since we haven't had much prosecutorial discretion in the last several years, is if you have filed an I-589 and then your case is either dismissed or admin closed, or maybe the answer is different for each, in terms of preserving the 1 year deadline, and then also your client's ability to be eligible for work authorization based on their pending 589. I think those are questions that the asylum seekers, it would be a really big deal if they lost their work authorization, or of course lost the one, having complied with the 1 year filing deadline for asylum cases.
I mean, I think this is a great question, and it's one of the reasons we're being really cautious on our cases is maintaining work eligibility, and so determining which are the best cases to seek some type of discretion on. Because I'm not hopeful about stipulations. I think probably what we're going to be seeing is agreements to terminate or dismiss, and which obviously would take away work permission eligibility.
And recall that administrative closure isn't an option for it's only an option in certain circuits for, right? And so like that docketing tool was taken away from the immigration judges over the last 4 years. And it's something that AILA is certainly advocating that should be allowed to come back, because that has been the vehicle through which people have been able to preserve their work authorization eligibility by having their case administratively closed, as opposed to outright dismissal or termination.
So I see a comment from Brooke that's a good point. If you terminate a defensive case, and then you could apply affirmatively.
Yeah, and I want to be really, I talk about the 1-year deadline. I didn't explain what it was, but asylum cases are generally required to be filed within 1 year of the date of entry into the United States. And so, most of the time that will happen, someone enters the United States, they're given a notice to appear in court. We used to have something called credible fear interviews. Maybe that's coming. It sounds like that's coming back. And so, they are given a notice to appear in court, and you have to file the asylum application, even if you have your master calendar date more than a year away, which will happen in many cases. You have to file the I-589 within that 1 year. And so if the case is terminated or dismissed, as opposed to admin closed, do asylum seekers run the risk that if ever the enforcement priorities memo changed, or they were to become a priority, do they lose that, having complied with that deadline in the future if they have to refile an I-589 if proceedings are reinstituted? And admin closure, my thought is, and somebody tell me if I'm wrong, with admin closure, the 589 remains pending, and therefore the person can continue to be eligible for work, and their 589 has been filed. But obviously, as Jen pointed out, that's not possible in many jurisdictions. Any thoughts on that?
Even then, I don't think we can guarantee to our clients that with admin closure, they'll still be able to apply for a work permit. I had a case admin closed at an individual hearing, prior to Trump, where my client had not yet accumulated the 150 days or 180 days that he needed. And the judge specifically put on the order, the asylum case remains pending, because everybody knew he wanted to apply for work authorization, and then USCIS denied it.
Oh man, yeah, that's another really good point, Tamara. So with asylum applications that have been filed, the person can apply within 150 days after the filing, and then they're eligible for work authorization 180 days after the filing. So if you admin close before that, that could end up, it sounds like, Tamara, in your case, having been a basis for denial because the time didn't elapse to make the person eligible. Someone asked, Leslie asked, if a client has a very weak asylum claim based on family, would you suggest asking for PD to admin close? I think, Leslie, sort of going back to what we just discussed, it would depend on a host of things and the priorities of your client, at least at this point. And of course, like the timeline of your case, how close is the individual hearing, that kind of thing.
But keep in mind that if it's a family-based case under the LEA decision, it might be a better case now.
Right.
But I do think weak cases, weak cancellation cases, weak asylum cases are going to probably be some of the best ones to try to terminate under the new memo.
Right. So Nicole asks, how long before the individual hearing can you reach out to DHS regarding stipulating to certain aspects of a case or granting asylum?
I think after you filed your documents, probably.
Yeah. And just a reminder that the deadline for filing documents is still 30 days for non-detained, 30 days prior to the individual
And
according to the practice manual.
Right, according to the practice manual. Yes.
The OPLA memo also points out that folks should be considering these issues at the earliest point possible in the proceedings, not to say that it can't happen like at the day of the hearing, but it certainly indicates a strong suggestion that attorneys, the ICE attorneys and the private bar be reaching out to each other earlier in the process. It's all about efficiencies, right?
That would be great if we can get that done. Just to go back to Brooke's question, I think we all agree that yes, right? You could, if you had filed defensively and you were still within 1 year of the date of entry, you then could theoretically file affirmatively once a case is terminated. I'm going to
also, if your client is a member of the Mendez-Rojas class, remember that.
Yep.
They're excused from the 1 year deadline.
That's right. And there's Joanna's comment to the same point. Let's see. Okay, so I don't know if we can't, I'm taking, speakers, can you please touch on matter of ACAA and how that makes it dangerous for us to stipulate only that certain requirements of asylum have been met?
I didn't reread ACAA. I know, is that the case that, did the BIA actually say in ACAA that you can stipulate? I don't remember.
It says when reviewing a grant of asylum, the board should not accept the party's stipulations to or failures to address any of the particular elements of asylum, including the elements of PSG. Instead, unless it affirms without opinion, the board should meaningfully review each element before affirming such a grant.
If the parties stipulate, who's appealing?
Yeah,
I'm not familiar with this case because, to be perfectly honest, ever since I've been practicing, stipulating to a grant, and in the jurisdictions I've practiced, stipulating to a grant of asylum was
Same, yeah. I had like 2 stipulations in 2010 one time.
Yeah, I think Joanna's right in her comment there that the stipulations of certain elements of asylum will not be accepted by the BIA. Just a little plug for those of you who are AILA members. We're actually having a roundtable conversation with some asylum and refugee committee members on ACAA on July 16th. That's free to AILA members. So definitely check that out because this is, I think, one of the many problematic BIA cases that came out in the past couple of years.
Okay.
Yeah,
So I think you
Kind of flown under the radar.
So I think here you would just put on your evidence. So, let's say there's a case where there's obvious past persecution. DHS won't say, oh, I stipulate that there's past persecution, but they'll say, I'm not going to, argue against it. Past persecution, or if you have a family PSG, a nuclear family, you put your evidence on the record and DHS doesn't necessarily stipulate to it, but they're not going to oppose it. Hopefully.
Yeah.
I think that would be okay.
Joanna says, I thought that admin closed 589s are still considered pending for purposes of EAD. I think that's true, right? What we were talking about was whether the clock had stopped at the grant of admin closure, I think was the issue in Tamara's case, Joanna. I want to get to a couple of because we're coming up, it's 10:50, well, in my time, it's 10:54. So I want to talk about, should we expect any more decisions like this coming from the Attorney General soon? And, what has AILA, Jen, specifically to you, what has AILA done in terms of advocacy? And then, how can sort of practitioners and the general public get involved?
Yeah, that's a great question. So I'll kind of go backwards because I want to put it on everybody's radar. You're talking about all the different nuances of particular social group, but and that having been defined by case law, but there is a plan in place to actually go through rulemaking to actually define particular social group. So for those of you who maybe aren't as familiar with that process, you might remember last summer, there were those big death to asylum regulations that were proposed by the Trump administration. And you probably got emails from AILA and from a host of other organizations asking you to submit your comments in opposition to those regulations, like why they would be so bad. A similar process is going to be coming through probably in October later this fall, in which as directed by an executive order in February. So if you step back in the way back machine, when Biden first took office, he issued a series of executive orders. And one of them was directing the Department of Justice and the Department of Homeland Security to work together to conduct a comprehensive review of the meeting of particular social group, with an emphasis of looking at how it relates to domestic violence cases and gang-based cases. And so that's part of the comments in these rescissions, that Garland is indicating that he basically wants to bring us back to pre-AB and LEA, and leave it until they can actually address and propose their rulemaking. So propose what they think through the particular social group means. And so that'll be an opportunity for many folks to weigh in. So in the same way that under Trump, we were trying to slow down their rulemaking by submitting a lot of comments that they were in theory supposed to read, this is an opportunity to really talk about all the issues that we've covered today and raise that to the administration. AILA has been advocating on a couple different fronts with the Department of Justice, but I think the biggest one that I'll highlight is just to take a really big step back and say, we need an independent court. So there's an inherent conflict of interest in which the Attorney General of the Department of Justice is making these decisions in cases that they're also supposed to be litigating. Certainly an independent court is not going to solve all the issues in our removal cases, right? It's not going to root out necessarily the systemic bias and racism that we often encounter in representing folks before the immigration courts, but it's a start. And so that's one of the things that if you go onto our homepage, AILA.org, we have a whole section of take action. So places where you can just fill out a very quick and easy template, and you put in your zip code, and it gets, you end up sending an electronic message to your member of Congress saying like, hey, this matters. And so if you hear about our push for the independent courts, certainly over the summer, AILA has been advocating for that we think that's a good first step. I'll point out that that the immigration judge in matter of AB, he was directed to after it was appealed, he was directed to reconsider the case and refused it. And sadly, I believe he is now on the BIA, on the Board of Immigration Appeals. So there's a lot of cleaning up that needs to happen within the Department of Justice. And the Department of Justice has many things on their plate, right? Immigration is not Merrick Garland's probably top priority. So AILA's trying to make it that a top priority because he's juggling a whole lot of other things. But that rulemaking is definitely going to be an area where we're going to be looking for folks who are who are basically crafting particular social group arguments day and night to say this is what will work. This is what will give the most protection. So having that protection first mindset, as opposed to what we experienced under the prior administration, which is finding ways to deny cases.
Definitely.
Well said.
Yes, very well said. Well, everybody, we're at 1 minute till the hour, so we're gonna let you all go. Jen, Tamara, Kate, thank you so much. I appreciate it. Thanks to all of you for all of your great questions and comments. Feel free to continue to leave questions, and we'll try to monitor it. But we appreciate everyone's continued advocacy for asylum seekers, and go team.
Woohoo.
Thank you, everybody.
Thank you.
Take care. Bye.